I know a lot of you know each other, but there are a number of new group members, so it's useful if you introduce yourself via the chat function as well. Feel free to make comments along the way, share updates, and again, we'll pick all of these up after the session and share them in our follow-up work. So we have a couple of new and updated initiatives to start this meeting off. So first of all, I'd like to extend a very warm welcome to our first speaker of the day, Tamsin Hyatt, who is the Director of Evidence at Frameworks UK. And Tamsin is here to discuss their Reframing Justice project. So Tamsin, take it away. You should have the co-host ability if you want to share your screen.
Well, thanks, Emmeline. And hello, everyone. I'll jump into the screen share now. Thank you for having me around the virtual table. I am Tamsin. I'm the Director of Evidence at an organisation called Frameworks UK. And we are a non-profit communications research organisation. And we essentially spend our time figuring out two things: how people think about an issue, and then what changes those things. And then we take this insight, this research, and work in partnership with different mission-driven organizations for social change. And our work is really evidence-led, rooted in cognitive anthropology and the social sciences. And it's rooted in one central idea, that when we can change the story, when we can change the narrative on a given issue, when we can reframe it, we can change the world. And I'll show you what I mean here with some footage, not on law or justice, but on child adversity. So a quick detour before we get into the bulk of the update, but a very short one. I have one interview with one woman asked the same question 2 times. She's asked about stress and its role in early childhood. And your challenge is to spot the difference in the before and the after clips. Because in between these 2 clips, she was given a story, a new, well-framed paragraph to read about child adversity, stress, early childhood. Here we go.
So what do you think about stress?
It's a normal part of development, in my opinion.
What's the effect or the role of stress? Again, thinking about young kids.
That causes, in my opinion, long-term damage to a child. A lot of the emotional developments and the learnings that are meant to take place wouldn't happen in that situation.
Did you spot that? How she thinks about the world, how she understands it has changed. From stress is normal to stress damages development. From no big deal to worthy of concern, worthy of action. And there's one more thing that she says that's important here. She says, in my opinion, both times, in the before and the after, even though she is saying something very different. And this is quite a strong linguistic indicator that she holds both of these 2 understandings in mind. We haven't tricked her. We haven't temporarily changed her opinion on an issue. What we have done with the new frame, with the new story, is draw out an understanding that was already there. It just wasn't top of mind. It wasn't her default way of thinking about the world and how it worked until she was given a different frame. Which brings me to Reframing Justice. It's a partnership between Frameworks UK and the Law Society to tell a new story, to reframe the narrative on the rule of law and access to justice in England and Wales. To create that new story that can change and build public understanding and drive change. And we've just finished the first year of this programme. And as part of that year, we've identified kind of different ways of thinking, how the public think and understand law and justice, and how they might think differently. What are the different understandings we could bring to the surface with the right story, the right narrative, framed in the right way? In year 2 of this program that we've just kicked off, we're going to be designing and testing different narratives and different frames that can do just this. But I wanted to share and update some of our findings so far. How people think about the rule of law and access to justice in England and Wales, and what this means for communications, for strategy, for conversation. Top line findings. People's default understanding of the rule of law and access to justice can be distilled down to about 4 things. That the rule of law and access to justice exist to prevent social chaos. Without both of these things, we would have anarchy. Justice is about crime and punishment, policing retribution. Money shapes access to justice. It's both a problem and a solution. And the rule of law and access to justice are under threat from social inequalities, from moral decline, and the presence of other cultures. Now, these are not the only ways of thinking that are available to folk. These are not the only ways of understanding the rule of law and access to justice, but these are the most dominant. They're the first response you'd get to a question, not the second. So we have a really rich data set to draw on as part of this work. And in the interest of time, I'm going to talk us through 2 of these findings, the first 2 to illustrate what we found. First up, rule of law. Law itself is seen as holding back chaos. When people think about the purpose of law, what it's meant to be doing in society, this is the idea that dominates. Law is necessary for a functioning society because without it, we would fall into chaos. And we call this mindset that we've identified, unsurprisingly, social chaos. There's not much here that is aspirational or forward-looking. This is a mindset that is structured around preventing harm. And when people apply this in talk, how we identify it in interviews or in communications, people are reasoning that law is the only thing preventing societal breakdown. And to share one example of where this mindset comes from, taken from some of our research, we tend to find that most communications, most stories in media, most things that are coming from the field focus on what the rule of law prevents. It's often positioned as a set of rules that require compliance with dire consequences if those rules are broken. And there's 2 consequences to this when it comes to public thinking. Because how the rule of law works, how it's constructed, maintained, strengthened, or harmed, is completely missing from the dynamic here, and it's missing from public thinking. It's not then really surprising that most people identify threats to law and the rule of law in, say, our moral decline instead of government underfunding, because we're reaching for things that are more immediate and obvious. And the second consequence to this focus on prevention leaves our field vulnerable to accusations that the rule of law and justice don't just prevent abuses, prevent harm, but they also prevent progress. It makes it easier for opponents to position law and justice as red tape or interference, impediments to getting things done. But we do have an alternative, a new way to build public understanding and drive support for change. We have a second mindset that is available to us. It's not quite as dominant in public thinking, but we did find it. This idea of social harmony. When people are drawing on a social harmony mindset, people think that law is something that is unifying, something that can represent and indeed create a shared understanding of a fair and balanced society. So applied in talk, people reason that the rule of law, access to justice, these are things that can and should bring balance. A social harmony mindset is one that sees both law and the rule of law as not only ensuring society can function, but can also function well. And in some of our additional quantitative work, we found that when people are drawing on this mindset in particular, they are more likely to recognize and acknowledge the role of lawyers in upholding the rule of law and ensuring access to justice. They're more likely to hold the idea that there should be a level playing field in society, and access to justice initiatives are a key part of this. And they're slightly more likely to recognize the existence of structural racism. And what's particularly interesting, that people who have used a solicitor, so just over half of our research sample, they endorse this mindset significantly more than those who haven't. One more finding. The second insight, that crime and punishment dominate people's thinking on justice. And it makes it that much harder for them to see the social, political, and economic function of law and justice. So when people think about what justice means, where it operates, how it works, people default to this idea that justice is about crime and punishment and not, say, access or accountability. We call this mindset that justice is controlling and punishing crime. And when people are using this mindset, they see the rule of law and justice as two parts of that system to control and punish. And other notions of law and justice seem to disappear from thought or discourse. Applied in talk, people focus almost exclusively on police, prisons, crime levels. And across our media sample, across our field analysis, we found that most materials focus on the criminal abuse of power. No single media piece in our work focused on prevention or the ongoing political, social, economic good of a functioning justice system. So this is not the only reason why justice is about controlling and punishing crime, is a dominant mindset, is dominant understanding within England and Wales. But this is part of the picture, because if we're not seeing communication, stories, narratives about ongoing good, people reach for the things that are more visible and immediate, the lack of police, the visibility of crime. And this is another problem for us, because this mindset in particular narrows people's thinking about justice to retribution and punishment. And when it's active, when people are drawing on it, they reason that improving justice is all about more and harsher punishments, not interventions like restorative justice or improving access to legal supports and services. With this mindset, it becomes that much harder for people to think about the role of law and justice in our political, economic, or social systems, and why we all need access to it. But a second mindset, again, is available. It's not the dominant one. It's one that we would need to do work to surface with narratives, with frames. A mindset that focuses on shared good and not just retribution for harm. So this is the notion, the idea that justice is all about righting wrongs. It's one that expands how people think about what justice does and potentially the social good it can lead to. Using this mindset, people are able to move beyond solely punitive thinking and make use of a more expansive and potentially more productive understanding of justice. Because justice here can mean an apology, it could mean a fine. Justice here is about getting what is due, fairness for the family of the person. And in our survey, we found that when people hold this particular mindset, they are more likely to also understand the rule of law as about ensuring social harmony. So I think I'm coming to the end of my allocated time. So I will just end on next steps. So if you're interested, you know what to look for. These are just a few of the areas of shift we're looking to make with the second phase of this program, the second year of the program. How we can build public understanding to be more aligned with how we understand the rule of law and access to justice to be. We're currently in frame development, where we'll be developing and testing different ways to bring these understandings to the surface. And we hope to have preliminary findings in September to publish in November. And if you do want to find out more, if you want to read any of our research reports, they are fully available on our website, frameworksuk.org. Thank you.
Thank you so much, Tamsin. That was really brilliant, and it was great to hear from you. We have a minute or two for questions. So if anybody has any questions for Tamsin, please feel free. You're welcome to ask them live, or if you prefer, you're also welcome to pop them in the chat. I think it's best if you have a question you want to ask live if you use the raise hand function, because with this many people, I can't always see if you just do it on your screen. So with that being said, does anybody have any questions that they'd like to ask Tamsin? Oh, I see. I think Simon Davey had a question. Is any of this being applied to how the Treasury think about justice?
So we have got some insights around how people understand money, the role of money in the justice system. And we see that it is applied in two different ways, to understandings of individual wealth, but also to understandings of government funding, how the government should be funding the justice system in order for it to function effectively. So we think there's a lot of potential in that space for us to be able to find the communication strategies that we can use to communicate with Treasury and to communicate and kind of campaign for additional funding in that space. It'll be a kind of key component of what success looks like for phase 2.
Brilliant. Thank you, Tamsin. And if anybody else has any questions for Tamsin along the way, please do feel free to tag her in your comment and ask a question. And Tamsin, maybe you can respond to those virtually in the chat. So now we're going to move on to our next presenters. So it's really lovely to be joined by Sarah Stevens, who is the Associate Professor of Legal Innovation at the University of Sussex and a member of the Online Procedure Rule Committee with responsibility to lay users. Antonio Pera, who is the Senior Policy Lead, and Andrea Ardlian, who is a Senior Service Designer with the Ministry of Justice. They'll be giving an update on the Online Procedure Rule Committee, as well as an overview of their recent work pulling together an ecosystem map. So I will hand it off to you.
Can you all hear me? Yeah, great. Okay, hi everyone. Some familiar faces and some new faces, so nice to meet you all. I'm Sarah Stevens. I'm one of the expert members representing lay users on the Online Procedure Rules Committee. So just here to give you a quick update or introduction to it, really, if you don't know what's going on with the OPRC. And also some of the MOJ team are here as well to give you more detailed explanation of the context and what's going on. So the reason that I'm really engaged with the OPRC work is this question of how can we make the justice system work better for people? And I think Tamsin's talked about that this morning a little bit in presenting her research findings. This ongoing question of access to justice and how do we build a system that works for the people it's designed to serve, both now and in the future. And of course, as we all know, that's going to involve technology. So this is the vision of the Master of the Rolls, this integrated digital justice system, which is an entirely smart system that operates online to identify and resolve issues between parties. So, and judges, arbitrators and experts will be responsible for the ultimate decisions, but routine or interim processes may be automated and resolved by algorithms, always provided that the parties know what AI is deciding and retain the right to appeal to a human judge. So his vision is around this ecosystem of online justice and analog in-person justice, sort of coexisting and speaking to each other. And the OPRC exists to develop the rules and the behavioural standards, both for the people involved, but also the data standards involved in that ecosystem. So it was established in June 2023 after the Judicial Review and Courts Act 2022. So you can go and read up on that if you want to. And it's charged with regulating online court services in civil courts, family courts and tribunals. And the key functions and responsibilities for the OPRC are to develop the rules for online court services and set standards for online dispute resolution providers. Because the vision is that there will be online dispute resolution providers that sit within this ecosystem. It's to facilitate the seamless transfer of unresolved cases from the pre-action space to online court systems. And the rules will be the place of proceedings of a specified kind. So the statutory instrument is being developed to confer the remit of the rules. It comprises 6 members. So Sir Geoffrey Voss, the Master of the Rolls, is the chair. Sir Andrew McFarlane, President of the Family Division, and the Right Honourable Keith Lindblom of the SPT, the Tribunals. And then the expert members are Brett Dixon, from his solicitor, and myself representing the lay advice sector, and Gerard Boyers representing the technology sector. And then we're supported by these subcommittees. So the OPRC sits along the top with sort of the final sign-off and the development of the rules, but we're building these subcommittees, a data and technology subcommittee, and a governance, rules and liaison subcommittee, where there'll be a lot of expertise that are consulted and meet monthly to really develop the nuts and bolts of what this is going to look like. You may have been aware of the recruitment campaign that has just closed, but that's been going on for a few months. And that's been opened across the sector. So just bringing you up to speed with where we are now in terms of timelines. So hopefully you are all aware of the launch in November 2023, end of last year. And then we've really just starting the subcommittee recruitment, developing the statutory instrument, and then really getting down to the work of establishing the principles of the approach to rulemaking and the development of the online procedure rules. So really, this is just a pause to reflect at this point. Just these are some of the things with my priority around access to justice. These are just some of the questions that I've been thinking through and bringing to the discussion around the unintended consequences, thinking those through when we're thinking about online justice. Additional barriers to justice. What's the problem for which a digital portal is the answer? Is the problem the same for all users? Because we know that justice and we know that technology capabilities is a spectrum. So everyone has that complex intersect of technology and legal capability coming together. And how does technology help bridge that capability gap? And then the last point here is that we know that justice is complex and disputes are complex and interconnected. And someone doesn't usually come with just one discrete problem. They have lots of problems that intersect. And so the Ministry of Justice has been doing this mapping exercise to kind of map out users' interconnected journeys. And actually, that's what Antonia is going to present to you next and show you a bit about that. So I'll stop sharing now and let the MOJ colleagues present their contribution. And then I think, Emmeline, is that right? And then we'll come back for questions at the end.
That sounds brilliant. Thank you so much, Sarah.
Okay, you're welcome.
Thank you very much, Sarah. Hello, everyone. So I'm Antonio Perra. I'm one of the senior policy leads from the MOJ working on the digital justice system. As Sarah mentioned, much of the work we've done in the past few months led to the development of the civil, family and tribunal ecosystem map. Up until recently, the MOJ had a visual representation of user experience, which we didn't feel really captured the true essence of what users go through whenever they have a legal issue. It was presented as a linear journey whereby a user will start from realizing that they have a legal problem and then sequentially move through a number of steps that will lead to resolution. But as Sarah rightfully mentioned, this is not really the case. User experience is complex. They often go through different bits of the journey. They might jump some stages or go back to others. So it's really far more complex than how it was represented. Off the back of that, we therefore developed this map, which, as you can see in the screen, is anything but linear. The idea behind it was to develop a tool that anyone could use in order to see exactly what happens to individuals who develop a legal problem and attempt resolution. This map is a interactive map. I mean, Andrea will do a little demo in a second, but just to quickly say, alongside capturing the sort of high level steps of the journey, you know, it also captures sort of key actions that users take, pain points. So, what are the issues that users are faced to as they move through the sort of the justice journey, as well as a number of other useful resources that really show in depth what users go through. This has been developed by bringing together years, in fact, possibly decades of user research, both conducted by the MOJ, its agencies, as well as externally, and it was launched on the 20th of November at the OPRC launch event, and we will be using this map in the next phase of our work program, which will seek to realize the vision that the Lord Chancellor and the senior judiciary have outlined last year. And it will enable us to identify possible policy interventions that could lead to the realization of that vision. So I will now pass to Andrea, who will talk a little bit about or show the map in more detail.
Yeah. Thanks, Antonio. So hello, everyone. I'm Andrea. I'm a service designer working in the same team as Antonio, trying to make some sense of this complex space and how we can improve it. So like it was mentioned, we started this ecosystem map with the idea of understanding people's experiences when they navigate this space. So in the civil, family, and tribunal jurisdictions, we call it an as-is map. So it represents the current situation. It's not necessarily where we're going to go. It's what is happening right now. So I'm going to walk you through an example to illustrate the structure better. But first, we can share the link, so it's open to anyone, and you can come in and have a play yourself. So just really quickly, how you can use it is like drag and drop, very simple, zoom in and out. We have at the top here different layers that I'm going to go through. So it's the high level stages, then we have some actions, some pain points, and then the providers that work in this space. And at the bottom, these are filters. So I will show you how they work when you can, kind of filter out or in something. So the main stages that we looked at. So we start from when something has happened. I hope this is kind of zoomed in enough for people to read. Then you go into problem recognition. Then in pathfinding, so we named pathfinding everything that's related to finding information and making a decision, like assessing that information and making a decision on it. Then that will go in kind of either negotiation, so an informal way of trying to resolve your issue, or dispute resolution, which is more of a formal way of doing it. Obviously, on the other side, you have courts and tribunals, and what's kind of connecting these two is accessing advocacy and representation, but also accessing financial resources. And everything is surrounded by information and support, because information and support is not just a stage that happens at the beginning. It happens throughout the journey and at different levels, different granularity, and in different ways. So we wanted to really show that it's something that encompasses everything. And as been suggested so far, that it's not a linear journey. People go very in and out of these things. And a lot of the times, quite a few times, till they get their issue solved. So that was high level stages. So I'm going to walk you now through an example with like key actions and then user actions. So imagine you are a family, a couple that breaks down, and you cannot agree on child arrangements. So the orange bubbles are like the bigger stages of what's happening, the key actions, and in yellow are the more granular actions related to a specific jurisdiction. So like I said, I've selected user actions and I've selected now family. So I'm only going to see things that are specific for family. So like I said, we are a couple, relationship has broken down, we decide to separate and we cannot agree on arrangements. Maybe we are married or not. That's not necessarily relevant. Then the next step will be, we need to understand that we have a problem and that problem is legal. And obviously there's an inaction point at any time that you can just decide to not do anything and just leave it be, or postpone it till it becomes really, really, inflamed. Then, so you've understood you have a problem and it's a legal problem, and then you need to identify that there are possible legal pathways, but maybe, and now I'm going to turn the pain points on, maybe you are actually sidetracked by your friends and family that say, actually, it's not a legal problem, you need to solve it within the family, don't go outside. Or they have some financial issues, and for example, the mom doesn't work, only the partner works. So there's a power dynamic. So how does that influence what people find and how they attribute that on themselves? So they need to identify what options are available, like in general. Then they would need to do an assessing to decide if those options are relevant to them. And here we've included a lot of the barriers and the motivation factors that people take into consideration when we make that assessment and decision. And for example, when we're talking about motivation, you can open this here and you can see all of the stuff that we found about what motivates people to take action. The same around capability. When we're talking about capability, we're talking about skills, emotional and psychological resilience, confidence and abilities, etc. And resources, of course, it's a big one. And this could mean from obviously financial resource, but transportation technology, etc. And then we continue. So they identify what options are available. They need to identify the individual ones. Then they need to decide which one best meets their needs. And then they need to decide if they want to continue with a support or they want to do it themselves. And then they need to choose a pathway, and then they need to get started on a path. Obviously, at all of these points, they are looking for information. We have expanded here on self-sourcing information. What sources are those? And I'm going to expand now the providers. So we've added here who are I'm not going to say main key players, but some of the more known players in this space. So where are people going when it comes to offline? Where are they going online when they're self-sourcing? What kind of information they're looking for? And here, when they're looking for expert advice and support, again, what does that mean? What types are they? And I mentioned providers. So we have here some private sector organizations. We have government departments and organizations, and also we have third sector. These are all filtered for family. So if I were to untick family, you would see all of them for all of the jurisdictions. So this is, I feel like I'm covering quite a lot and speaking quite fast, but I'm just giving you a flavor of, if you are interested, to maybe like access it and have a play with it on your own. but yeah, so it's quite comprehensive. It's tried to cover as many issues as possible, or to uncover as many issues as possible, to give us kind of like an overview of where the biggest issues are and where we can go next. I'm not aware of time, like how much time.
Andrea, actually, we're kind of coming to the end of time there. I hate to stop
Perfect.
you because it's been a brilliant presentation.
No, it's fine.
I think just for the interest of time, we have to move on to our next section. But I do see that there's another question in the chat. And as always, please do feel free, everyone in the meeting, to ask questions. And hopefully the three of you guys will be able to respond to those in the chat. But thank you so much for that discussion. And I think it will set us up well for the next section of our meeting today. So thank you very much. So we're going to use the rest of the session to cover the topic of dispute resolution. Currently, we are working with the SRA and the Law Society on the Regulators Pioneer Fund project, which my colleague Jaira will be able to pop a link in the chat that gives a little bit more information about this. And this seeks to explore how technology can be used to support the delivery of and access to dispute resolution services. So we really want to use the session to provide some of the key insight into how dispute resolution can support access to justice, as well as what barriers might need to be addressed. In order to do that, we've highlighted a couple of key discussion questions, which we've shared on the agenda, and we're about to hear from some really brilliant speakers who will touch on these points. We're still in early stages of the project, so would really value anything that you'd like to add. So as always, please do use the chat function or get in touch with us after the session on any of your thoughts or things that you'd like to include. So to start off, I'm happy to virtually welcome Victoria Speed, who's the network manager at the Employment Legal Advice Network. Unfortunately, Victoria was unable to make it in person today, but she's very kindly prepared a video recording for us, which I'm going to play in a moment. And she's setting us up really well for a discussion on all of this with an overview of the challenges with using mediation and how technology might best be utilized in settlement cases. So if all goes according to plan, I'm going to play the video and you should be able to hear it, but please do someone give a shout if you realize that you're unable to kind of hear the video. These things can be finicky.
Hi everyone, my name is Victoria Speed. I'm a consultant in the not-for-profit sector. I run the Employment Legal Advice Network, which is a network of Trust for London, and obviously lots of not-for-profit organisations delivering employment advice. During the first lockdown, I set up a pro bono mediation service with Camilla Palmer, and I became a workplace mediator in 2020 and have conducted a number of mediations since then. And I'm really grateful for this opportunity to share some of the thoughts I have on mediation in the world of access to justice with you today. I'm really sorry I can't be there to be part of the discussion, but I'm grateful for this opportunity anyway to share these thoughts. So I know we don't have long, so I will just proceed with telling you sort of about 4 of the challenges that I think we need to be aware of. Number one, I think, is terminology. So we experienced during our trial mediation service that a lot of the public that we spoke to just didn't really understand sort of mediation, what that actually meant, what it looked like, how that played a role alongside or instead of litigious proceedings. There was also, I think, in the employment space, even more of a challenge because quite a lot of organisations now, some offer workplace mediation. That might be with a HR person in the workplace. Then you've got post leaving, potentially mediation to try to resolve disputes. Then you've got the conciliation service offered by ACAS. And then now you also have the opportunity to go through judicial mediation once you're in the employment tribunal. And sort of there's just a need to be clear about some of the differences of those things, but also just generally around things like how they work. Is it online? Do you have to be in the same room as somebody? Do you have to, can you do it on the telephone? All of those things, like really practical things, as well as the terminology. The second is, I think, confidence, lack of confidence in mediation as a tool to find a solution. I spoke to a lot of people for whom the final word of the judge was really what they were looking for. They wanted a judge to determine or to tell them that they were right in thinking that they had a case. And the sort of notion of going to a mediator and being almost like taking control of the problem and finding a solution to the problem was something that they just didn't have confidence in, that as a process. And actually, I think that changed for those that we then conducted mediations with. I think actually that changed, and a lot of people felt that kind of opportunity to talk to a mediator really did give them sort of confidence in the idea that they'd found, and empowered them, in fact, to find a solution for themselves. But that was just something that we had to overcome when we were talking to people about mediation. Also, employers, we encountered a number of employers who didn't want to go to mediation because they felt that it would be setting a precedent. And again, like slightly surprising maybe, but yeah, they sort of felt like, well, if we go to mediation, we might end up having to pay something or do something, whereas we're pretty sure that this is just going to go nowhere. And we challenge this person to take it all the way to an employment tribunal. And then the final point that I sort of wanted to raise was just probably one of the biggest issues really in the whole thing, which is lack of legal support and legal advice in the employment space. I mean, obviously there's no legal aid in employment advice other than sort of very low paid workers with discrimination who are eligible for legal aid in discrimination cases. And so without that, you're sort of reliant on grant funded employment advisors, of which there's not that many around the country. And in the absence of legal advice and legal support, lots of people just don't really understand what their claims are, what those claims are worth. They don't necessarily understand that there's a duty to mitigate your loss. And they don't understand necessarily that they might go to a tribunal and the tribunal might assess that they perhaps do have a case, but then they would potentially be looking at what the case is worth. And it might, there's potentially a big difference between what they think that they're going to get and what they actually end up getting, even if they are successful. And obviously being successful is not as easy or straightforward as everyone might think at the start. And so without that knowledge, it's difficult to, I guess, go to a mediation and be willing to compromise. And I'm going to give an example of that. I sort of spoke to somebody who'd had some legal advice from a volunteer of a not-for-profit organisation who'd explained that they might have several claims, and they also explained what these claims were worth. And the night before the mediation, this person told me, like, I can't settle for anything less because this advice that I've had said, you know, I can't remember the figures, but like, let's say they said, oh, well, you're going to get 20,000 if all of these claims are successful. This is worth 20,000, and this person said, I just can't, like, I can't go. I'm not prepared to do anything less than that. So they refused in the end to come to the mediation, even though it was all set up and ready to go, because they just felt like there was no way they could move because they'd had this legal advice. So that's the challenge. It's like they did have legal advice, but it wasn't like, it was just sort of 20 minutes and it was like talking about what might be possible. But actually, really, people really need to understand, again, you know, what their particular claims are, what the value of those claims might be. And really, in essence, like an understanding of the challenges of, and also the full costs of going to a tribunal, because obviously it's not just that you go to a tribunal, you have to pay to get there, you have to potentially miss work to go there, you might need childcare to go there, you might need to stay in a hotel, all of those things that should be factored into sort of a consideration of what your claim is potentially worth. But it's difficult because it's not necessarily people's understanding of justice in the public. I finally just wanted to say that I'm always looking at new ideas for AI and tech solutions in particularly in the employment advice world, you know, in specifically with the absence of legal advice available, then, you know, I think we have a duty to kind of consider some of these solutions and certainly to try to steer them in a way that I think would be really helpful for the public. And I have been quite heartened by some of the dispute resolution tools. And I think you've got Robert with you today talking about the Settle tool. But I guess what I just wanted to point out with that one in particular, and what I think is something that could be really helpful, is this sort of visual tool that can go alongside the sort of valuation of a claim. So for example, with Settle, there's a graph and you start at the beginning with so what you think the value of your claim is, and you have to put in, you know, what the actual costs involved are in bringing a claim. And then you can see how that looks on a graph, and you can see that there's this sort of section that you think from the beginning of your claim to potentially the end, there's like how your graph alters depending on where you're at and how long you are into the process as to where it's beneficial to settle and where it's beneficial for everybody to settle, in fact. And I think like seeing that kind of visual tool is a really helpful thing. And I think the more that we kind of get used to the public sort of seeing that sort of thing and understanding what it means, then it will be really useful for them to kind of use mediation as a tool to succeed, to sort of basically kind of come up with a solution and then move on. Having said that, back to the point about legal advice, and to do that without really a full understanding of your claim and sort of what it's worth and the risks of that claim is really difficult. So yeah. Anyway, if you want to join ELAN, please do email me. I'm victoria@trustforlondon.org.uk. And if you want to talk about workplace mediation or mediation in general in the employment space, really happy to have a conversation about that. Thanks for having me today. And I'm really sorry I'm not there to join in, but yeah, I hope the session goes well. Thanks. Bye.
So I think that was a really great lead-in for the remainder of the session that we have. And Robert, who she mentioned at Settle, unfortunately wasn't able to present today, but I'm sure we'll get him at a future session. And we have some really great tools that we'll be presenting momentarily. And I think kind of goes to that point of thinking about these ways that we can use technology to help increase accessibility for people and the ways that we develop technology and thinking about how that kind of user-centered design, what that looks like, I think are some of the key points that we'll be hearing from some of our brilliant speakers. So without further ado, we're going to move on to our next presenter. So I'd like to welcome James South, who is the Chief Executive at the Center for Effective Dispute Resolution, who will be able to give us a bit of an overview on alternative dispute resolution, its challenges and effective uses, as well as new developments in this space. So James, over to you. Thank you so much for being here.
Great, thank you. Thank you. Just testing, you can hear me okay?
Yes, we can hear you.
Great. Okay. So yeah, hi, my name's James. I'm the CEO of the Centre for Effective Dispute Resolution, CEDA. I've been a mediator for 28 years now, and I've trained and consulted on mediation and dispute resolution in about 40 different places around the world over my career. But I started my life as a lawyer and mediator in New Zealand, working for the New Zealand Tenancy Tribunal, mediating as a staff mediator, about 40 cases a month. And I'm raising that for a reason, because when I mediated in New Zealand, access to justice was a really key part of the thinking about the use of mediation in New Zealand. So, for example, under the statute that I mediated under, it was one of the primary purposes for having mediation in the statute. Access to justice was one of the key reasons. And also the way we ran the service, in terms of thinking about giving advice, accessibility to use mediation, protection of the individuals when they're in mediation, ability to access the tribunal when they required it, all focused around access to justice. And what surprised me, I guess, when I came to the UK to continue my career was in mediation circles, which I'm part of, dispute resolution circles, access to justice didn't really figure as a primary discussion or concept when thinking about mediation. And that's really continued over my 20-odd years here. So, and it's a point I will return to shortly in terms of what does mediation mean in relation to access to justice. Just briefly, if you don't know who CEDA are, I guess we would say we're the original disruptors in the UK of court-based dispute resolution and civil disputes. So we said from the 1990s, there's got to be a better way of just pushing people into the court system. And we over the last 30 years, we have delivered mediations and other dispute resolution processes. So we run about 30,000 cases a year, both in consumer redress for consumer disputes, for example, in sectors like communications, aviation, and others, and also do mediations through our civil and commercial teams. And we do a lot of low-level, low-value cases, employment and workplace cases, similar to the previous speaker, and also provide mediation services for the county courts in the Central London County Court, Leeds, and about to start in Bedfordshire and Luton. So that's sort of what we do, as well as train mediators and work in organizations to help people avoid conflict and get better at managing conflict upstream, if you like, within organizations. What I wanted to cover today, if I could, just as three things really. I want to go a little broader and just think about why dispute resolution actually helps access to justice, because I think we skip over that. You know, what is the real benefit to mediation in terms of access to justice? I then just want to maybe bring people up to speed about the recent developments and how things are changing and where we are currently. And then maybe just end to think about some of the challenges in using mediation as we go forward in relation to access to justice and some of the issues we're going to need to think about as I think we'll see more and more mediation in the civil justice system. So the first theme is, you know, how does mediation help deliver access to justice? And let me start with a story. I mediated a case a few years ago now in the Central London County Court. A husband and wife were unrepresented, suing their builder who had done some building works for them, and they weren't happy with the result. So we get into the mediation in the county court Moffat building, and the husband was pretty sure, I want justice. I'm going to go to the court, I'm going to tell my story to the judge, and the judge is going to give me everything that I want. But what evolved over the course of the mediation was a clearer sense of what that individual really needed. Because what he really needed was, he wanted some compensation. He wanted some acknowledgement from the builder that things had gone right. And just as importantly, he wanted out of this litigation for financial reasons. He understood the cost consequences if he lost. And importantly, for personal reasons. His wife, in the mediation and previous to the mediation, threatened to leave him if this hadn't got sorted, because the stress on them as a couple had become unbelievable. So in the end, they got a result which met those needs, and I would say in the end met his need for justice. So, I mean, I hope that story illustrates why I believe dispute resolution techniques such as mediation are fundamental to achieving justice. It was one of the reasons ADR was started back in the United States in the 60s and 70s. And it really comes to what we mean by access to justice. And while I'm sure this forum's discussed this at length, what interests me in legal circles is how they often define it. All too often, lawyers view and discuss access to justice as exclusively referring to the right to access the courts and the right to access trial. And we've seen this a lot recently in discussions about making mediation mandatory. One of the arguments deployed against that by the legal community principally was, well, that would remove people's access to justice, by which they mean access to trial. Now, this was refuted and by the Court of Appeal in the recent decision of Churchill, and saying that was necessarily the case. And I think this is a much too narrow definition of what we mean by access to justice. If you flip it and focus on what disputants want, then a more expansive view becomes clear. Well, of course, they want ultimately to retain the right to go to court if they need to. Individual disputants normally, what for them is more important is resolving the dispute in a cost-effective way, which is fair, and ensuring that they have the opportunity to be heard and that the resolution meets their commercial, legal, and personal needs. And this pretty much sums up what mediation and other forms of dispute resolution can offer parties. So in this sense, I think access to justice means access to dispute resolution. I also wanted to draw a link to another theme which we talked about already, is the use of technology. If you had asked me whether technology helps dispute resolution, and if you asked me that in 2020, I would have said no, not in any meaningful way. But the pandemic has really changed the way things have evolved with technology. And clearly now, during the pandemic, 100% of cases of mediations were done online, and still now, 2 or 3 years later, 50% of cases are done online through our centre, and probably a higher percentage for lower value cases and employment and workplace type cases. So this not only lowers the ancillary cost of engaging in mediation, for example, travel and venue costs, but it also allows parties to feel more comfortable in engaging in mediation from the comfort of their homes. And that lowers the barriers to engagement. So hopefully that sets out my view about how sort of dispute resolution fits into providing access to justice. I just wanted now to cover some of the main developments that have happened. And I think what we've seen is a change. I mean, there have been a number of blocks over the years to mediation being involved in the civil justice system. You know, we had initial skepticism that this process, seemingly so simple, could work. But after 30 years of experience and settlement rates routinely at 70%, at our centre, that's what they are for the last 30 years, it shows that it can work. Lawyers 30 years ago probably were more in our job is to litigate this. That culture's changed now, I'm pleased to say, and lawyers, litigation lawyers, and dispute resolution lawyers understand their job is to provide a resolution for the clients, whichever way is the most effective. We've seen institutional change, which has been slow and blocked at times, but now beginning to really take to really have a step change in changes to the institutions of justice and the courts and the way mediation is incorporated into that. And the other main problem we've had is low voluntary uptake. I mean, in 2020, there were 2,470,000 contested civil legal claims, and of those, about 16,000 were mediated. So that's 70% of civil cases. So voluntary use of mediation has not really provided the step change to get people into this alternative process. But again, as I said, things are beginning to change, and we may see more use of the mediation in the court system in the years to come. So what are those developments? I'm going to summarize them for you shortly. And they best can be encapsulated by the comment of the Master of the Rolls, where he said in 2021, as I said before, ADR should no longer be viewed as an alternative, but as an integral part of the dispute resolution process. That process should focus on resolution rather than dispute. And I was interested to see the map that the MOJ produced, which almost is a physical representation of what the Master of the Rolls said. You can see it there. You know, you had the court service, but you had negotiation and dispute resolution on the other side of it, with the wraparounds of advice and information. We've also seen the MOJ being very active in the use and consulting on the use of mediation in the civil justice system, and we had their report, their consultation in 2020 with their reports published in 2020 last year. So we've got the government and the judiciary pulling in the same direction, and we're seeing some key changes. So from spring this year, the expansion of the small claims mediation service to become a mandatory scheme for all money claims, housing conditions, and personal injury claims up to £10,000, which is the jurisdiction of the small claims court. And this is estimated to be about 100,000 cases a year, which will have to go to mediation. So that's going to be a step change for small claims disputes. If this is successful, the MOJ have already announced that they will consider extending it more broadly into the county court for the other vast percentage of cases in the court system. In addition, the recent judgment of the Court of Appeal in the Churchill and Method Tidwell Borough Council case, which set aside the block on judges being able to order mediations to parties in their discretion, something that's been blocked for the last 10 years because of a judgment of Lord Justice Dyson and Halsey back in 2004. But now the courts are free to order mediation off their own initiative, which you will see more parties going through mediation right throughout the court system. And finally, we're also seeing discussions by the Civil Justice Council to include mediation as a mandatory step as part of pre-action before you can file a case in the court system. So we're seeing quite a lot of development. We're likely to see quite a strong uptick in the use of mediation. I just wanted to end by thinking about, well, what does that mean in terms of what are the issues we need to consider to make that more effective within the court system or civil justice system to improve access to justice. The first thing is better integration, which has sort of been touched on already. The court system is already complicated enough for disputants who are often confused about what to do and where to go. If we add on top that they have to go and interface with a mediation provider in order to resolve their disputes, it increases the risk that the system becomes even more complicated. It's not just going to the court, we're going to go somewhere else. Now, to give you an example, in the county court, they're now looking at having multiple mediation providers in the county courts to provide mediation services. So that sounds good. Competition is good, lowers prices, makes people be innovative. The risk, I think, though, is that there'll be so many providers that disputants won't know what to do, who to choose, or on what basis to choose. So I think we do need a better way of interfacing this. Is it a one-stop portal? Is it connecting with clear advice? But we need to think carefully about that, because the intention is not to confuse people by adding this on top. And I think legal advice services play a key part of this, and they also need to be integrated so that the whole thing's working well together. Use of technology. Technology is great, and as I've already said, it lowers the barrier for access for mediation. But again, we need to be careful that it doesn't provide a block to access as well. A couple of things just to point out here. Again, I'm pleased to see the work of the OPRC.
James, I'm so sorry to interrupt you for 1 second. Do you mind if we have to move on soon? So if you maybe have some concluding remarks.
I'll wrap it up quick. Yeah.
Perfect. So, I'm so sorry.
No problem. I mean, the tech can be a problem, right? I mean, in summary, if it doesn't all interface together between the court service and the mediation services, then it's going to be more confusing and more cost because you have still manual management. So you need that system to work better. Just a couple other things to work out for. Legal advice has already been mentioned. I'm not going to mention it again, but it is important that people have legal advice prior to coming to mediation. And the other point is that people need to feel that they are protected, and we think about vulnerability for people going through the mediation process. So I'll in summary, those are the things to watch out for.
Thank you so much, James. That's a brilliant overview, and I'm sorry that we're running short on time, but I appreciate that. Feel free to pop anything else in the chat if you weren't able to kind of cover it. And again, people feel free to ask questions. But for time's sake, I'm going to move very quickly along. We're thrilled to welcome Simon Goodrich, who is the co-founder of the Australia-based platform Portable, who's going to be demoing and presenting on their tool Amica. Simon, it's great to have you with us today, time zone difference and all.
So I'm going to talk about some of the work we've been doing for the last number of years in family law, and about, I guess, the tangible way that we're bringing online dispute resolution as a way to solve this issue, both here in Australia and now more globally, and that idea of some of our learnings and insights. And I'm really doing this to also start to connect with your community in the UK, and be fantastic to connect with folks. I'll just put my email in the message, which is there. Great. So a bit about Portable. We are an org that has a mission to seek out areas of change and really bringing researchers on in tech. We've been operating for 18 years in Australia on about 1,000 different projects. We're really focused on how do we make justice more human-centered. We've crossed out Australia into the world as like a broader part of what we're seeking to do. And this is Amica, which is a tool that we've developed with National Legal Aid and the Attorney General's Department, Australian entities, where we're going through and being able to help folks separate without the need for a lawyer. So I'm going to talk today about a bit of that journey, how we went about it, and what our roadmap was and what it's going to be as we go forward in that part. This is a bit of a timeline where we there was initial ask and looking around this from National Legal Aid, which is the representative body of all the different states. We have another area of government that you folks do. And winning that sort of big international tender, they were very interested in like what was happening with RecWise at the time in the Netherlands, which going back in 17, 18 was like the global standard. And we sort of worked through and bringing a very human-centered concept rather than a solution one necessarily, to be able to sort of go through and do the research of seeing what we could do to be able to assist folks in helping to separate. It's been live now and operational since June of 2020. And in that time, we've added a whole range of different features that are really being led by users, such as a desktop version, which is originally mobile, We've got payment gateway, so for those that can afford it, pay a very nominal amount, as well as also developing superannuation, I'm not sure, retirement fund splitting, and also a tool and product for one individual to go through that process on their own without the need for necessarily having a partner. And we're also, as you'll see in the last one, expanding this out internationally in conjunction with ODR.com out of the US with a person called Colin Rule, and also in terms of working with the Inter-American Development Bank and part of our broader reach out into other parts too. So works, you know, where we wanting to really be able to sort of get to the point of how do we actually get people to solve matters. And part of that was that sort of how do we use technology in a conversational style and interface to be able to guide that part. And we worked a lot with mediators to then be able to sort of get to the point is how can we get people to agree to things sooner? And at what points can people be making decisions they're comfortable with on their own without lawyers and that process too? And I know that when we heard from Victoria before about, I'm not familiar with Settle, I'm really looking forward to looking into it, some of those sort of visual cues that go through it. So a lot of this is like human-centered in that way of mapping the workflows, working with folks through that process and testing with audiences, and very much following the UK double diamond approach, which is now 20 years old, of how do we solve the right problem to then solve the problem right. Very at the core of the things that we did. We didn't come with a very predetermined view of the way to do it beyond having a HCD focus and a mechanism to be able to work through that. So this starts to show you, I guess, that way of how like from prototyping to more medium-sized fidelity to tying into what it is now, where on the screens left to right is this ability for people to be able to communicate. There's a multitude of steps. We've tried to reduce as much as possible, but this idea that people are effectively building statements and then getting the other party to agree or not agree and being able to move through those gates, as well as also having interactions within the court environment to be able to sort of finalize that from a process of a legal standpoint. So the introductory screens goes through that part. You can go to I'll put a URL. There's some of it is going to be limited because you're in the UK, not in Australia, and it's got two-factor authentication to an Australian number. But I'm just going to put a URL in. This will give you a bit of an idea of part of that experience too. We go in, as I mentioned, you create statements, and then that is like this single user Amica, which I've just shared you with, where we've seen that like this came about because from our research, people were not inviting the party B. They were setting in and using it really as like a calculator, like, well, what could I get in a view of a separation? So this was something that they went through and delivered as a part, and it gives you this idea of how you go through the division. So you'll see there that, like, you know, you can see there we suggest it would be fair for you to receive, and we're actually built a synthetic data bank initially. This is a number of years ago. To really guide like what would be a fair assessment, and that's checked off by a lawyer, partly because I guess there's a view of that within legal aid, but it's fitting within like 1 or 2%, which is really good and something that we're really stoked about. But it's this offer piece where it's like we give you a suggestion based on those parts, and then you'll be able to go back and be able to tweak that to the point where you're both selling the process and seeking to agree. You make your offer, they make your own offer. Should be when it's outside, there's like a mechanism to tell you this, and whether it be things around wording and changing and so forth. You had your reason why you think that should be different. Then, you know, the offer is sent to the other party, and this can all be done in like real time, could be done over a period of days and weeks. It's fascinating looking at the data to then really get the party A receives and they can make their own with the intent, like, can we get to that part? And like, we've got a mechanic that it's like, well, if you can't get there 3 times, then this probably isn't the service for you. And how might you be referred to other parties, mediators, lawyers, to be able to support you through that process? They then party B gets the offer, and then we've also got consent orders as part of the work that we do. So I can fill out addendum information on this part. This is quite a popular item there. And I'm going to talk a bit through numbers because Emily said you'd like to know numbers. You know, we've dealt with nearly 10,000 matters registered there. Not all of them necessarily go to the final point, but it's also that role of like, where are we providing legal information and where legal advice and effectively legal resolution. But you're seeing the type of numbers there. We're at .gov.au. We partner with, and I'll talk to it a bit about how we partner. We're Portable's a design and technology studio, or effectively like a venture studio, interested in how do we not only meet but exceed folks' expectation of government. So it's a very sort of core part of what we do. I thought I updated this. Here we go. So this gives you an idea over time of the amount of matters generated per week, how many parenting plans. So these numbers aren't like massive, but they're pretty interesting. Like, we're not necessarily throwing a lot of advertising and marketing yet, but everything's trending in the right direction for us and looking at that part. We mentioned about the divisions are up, that's 16 a week. The consent orders we're getting are up there. And then also like it's starting to make, not that the intentionality of this is revenue, because it was set up by a legal aid body, but like there's something there in trending, and especially in that part that there's no reason this could be making $500,000, $1 million in a very short amount of time. And I think what's really interesting about that is it's being able to demonstrate to people in government and others, like, how do we create opportunities where we don't necessarily have the capital expenses environment, you know? And I look at a lot of friends in the UK. I know you guys are pretty skinned at the moment, post-Brexit and a whole range of things, and I don't envisage it's going to get any easier. I'm good friends with the folks at We Are Digital. We do a lot of work with His Majesty's Court and Tribunal Service, and I mean that. So basically, like, you guys are going digital because you got no cash after Brexit, right? That's basically what it seems like in the UK. Don't know if I'm right or wrong. Please come back and tell me if I am. But it's like the point I'm trying to get at is like, rather than necessarily waiting for authorizing environments, how do we, and by we being here technologists, designers, people in government or legal centers, be able to really put forward ideas about how we can solve issues for folks? Because the goal of this is not money per se. It's about being able to serve a purpose in the 1.4 million folks that sit in there, but it's also being able to show that mechanism as a part. I'm just going to end with like talking a bit about, this building ecosystem, right? What I mean by this is like you've got the problem owner, fixer, and funder. Sometimes it's all the same all. And that works okay, but I think where it really works well is where you can have someone for each of those. So this is Amica, where National Legal Aid have the problem, the funders are Attorney General's department, and we're in the middle as this fixer, where the CTO, the design part, with the product manager piece. And in our experience, we've seen that people like National Legal Aid don't necessarily have the culture, the resources to be able to build that product muscle, and funders themselves aren't usually that adept or close to it. So how do you create environments like this to be able to sort of create ecosystems where these things can get behind that part? This is something I'm very interested in seeing what that means and how that might scale. And right now, we're taking Amica International. This is like a divvy part. We did a lot of the wireframes that we did as a process of separation, but it's also now we're like taking this into an Ecuadorian context, because what's Australia and Ecuador got in common? Absolutely nothing, beyond them being nation states that have parenting parts. But it's also being to that opportunity, and we're sitting this on top of this part as in like, how do we scale the work that we're doing? We're doing this at the moment through an international aid grant, but it's that part about how might we work with folks to be able to sort of divide the part, because a lot of this is about learning from our research a number of years ago. It's about knowing those sequential steps. And there's also the view that, well, is Amica something that can solve for like anyone? Well, it's probably not just simple stuff. It is getting more complex. We've validated that model, and now we're looking at how do we create these examples in more international parts. And the reason I'm here tonight in a smelly alleyway next to a bin is like, well, what could that actually mean within a UK context too? So I'm going to stop sharing, folks, and that sort of goes through what I wanted to cover. But I'd love to see if there's any thoughts, comments, questions from the floor before I go back out of this smelly lane and back to the bar that I was at before.
Thank you so much, Simon. I think what we'll do is, just to make sure that our last speaker has enough time to give his presentation, we'll move all of those questions to be virtual. So again, please do throw those in the chat, and hopefully, Simon, you can stay on a few extra minutes to answer those. But thank you so much for being with us here today, and I appreciate that it's late in the time zone. And it's just been really lovely to hear from you and see that platform. It's really exciting. So last but certainly not least, I'd like to extend a really warm welcome to Austin Milne, who is the founder of the Shake Dispute Resolution platform, who's going to be giving us a bit of a demo of their tool, which provides a low-cost route to settlement. So Austin, thanks for being here.
Thanks, Emmeline, and hi everybody, great to be here. I'm very aware of time, so I will rattle. So my name is Austin Milne. I'm the founder of AXM Studios, builder of the Shake Dispute Resolution platform. I've worked in the UK as a legal sector for around 25 years as litigation solicitor, legal process improvement specialist, and legal ops lead in national law firms. In litigation of financial disputes, it's generally in the best interests of parties to reach settlement quickly and cheaply. Whatever the nature or whatever the value of the claim, most parties want to move on. But standard route to mediation can take several months, and for represented parties can obviously cost thousands of pounds in fees, and court waiting times being over a year. So Shake is an impartial dispute resolution platform. It enables parties to negotiate financial settlement of their disputes at a fraction of the usual cost, and in just a matter of days. So once parties have taken a view of their liability and their likely exposure, they agree underlying terms on the platform, and then each submits a series of proposals for settlement. Shake then assesses these pairs of proposals in turn and declares settlement where there is overlap. So unlike other negotiation approaches, neither party discloses any information to the other unless and until settlement is reached. So that other routes to resolution aren't compromised or delayed in the event of settlement not being reached. And it's also no settle, no fee, so there are no barriers to use, and parties only pay a fixed fee if settlement is reached using Shake. So while it has to date been operating in the field of commercial disputes, it can be used wherever two parties to a dispute where there's a financial solution and they're both genuinely seeking pragmatic, cost-effective resolution at the right level. And its most seamless application will be as part of those processes and forums for addressing disputes that already exist, whether they be online or court-based. So for instance, in the small claims court, where communications may well have broken down between unrepresented parties, Shake could be embedded as a precursor to the planned compulsory mediation, enabling parties to conduct a negotiation without the need for direct communication. And then settlements here would avoid the need for that mediation and therefore reduce the court costs. And subject to OPRC's direction, I hope that Shake will operate as a tier 2 solution in due course, providing that non-court-based dispute resolution service and helping reduce court wait times. So I'll give you a really quick demo to give you a feel for how quick and easy it is to use. And as we go through, please be thinking about where opportunities might be for using Shake for the benefit of those individuals and groups that are represented by everyone on this call. So I'll share my screen. Just if you can confirm you've got that, that'd be great.
Yes, we can see it. Thanks, Austin.
Great, thank you. So I'm going to use James's example. So we'll take let's say we've got a house owner. He talked about a builder. Let's say we've got a house owner who's claiming back £3,000 from a builder who's walked off a job, let's say. The builder has refused to return more than £1,000, saying there's work and materials been invested and the communications between them have broken down. So now either party can start a Shake, and I'm going to act here for the house owner. So I'll log in. And this is my dashboard. I can see all my completed Shakes down here, my active Shakes. And if I've got a card up here, it shows I've got an action to take, but I'm going to create a new Shake here for us. And what I'll do is give this Shake a name that means something to both of us. You'll see down the left that this is the course of a Shake. I can choose a category. In this case, it would be other. I can put a matter reference that means something to me, only the other side won't see that. If there are a funding client partner or insurer, I can put that in. And here I'm acting for the claimant, the house owner. I'm going to acknowledge that there's a fee to be paid in the event of settlement. And this is set at a commercial level at the moment. So I'll create the Shake and proceed. Tells me I've done that. And now the next stage is to set the terms and invite the other party. So we need to upload the terms, the underlying terms of the settlement, and the scope of the dispute needs to be clear and agreed. So this version of Shake is designed for use by legal representatives, so the terms are likely to be in the form of a simple settlement agreement. In true Blue Peter fashion, I've got one that I prepared earlier. I'm going to upload it. Interest of time, I'm not going to go into it, but it's a template settlement agreement. There's a proposal deadline here. This defaults to 2 weeks because that should be plenty, but if the parties need a different timeline, they can add one there. We get to choose whether to include costs, so whether it's a global settlement or whether we're just looking at damages. So for here, I'll go, yep, include costs, and then we invite the other party. So the other party's representative, whoever that may be, whether an advisor or a lawyer, you add in their details, and I know that he's at ABC Law, and I tick here to confirm that I'm happy to be bound by the terms that I've uploaded if we do settle. So I invite the other party. Shake has now sent an email to the other party inviting them to engage, not committing them to anything, sends the terms. So I'm going to log out as me. I'm going to log back in as Bob, the defendant's representative. And we can see here that there's a new card up the top. This is his dashboard. He's got a new card that says build a claim, which is the new one. So he can click into that, and he can see that I've given it the Sheikh name and who sent it to him, and he might add his own matter reference in here. He's acting for the builder, so he's got a reference there, and he also acknowledges that there's a fee to pay in the event of settlement. The next thing that he gets to is to review the terms that I uploaded in the first place, that the originator uploaded. At any point, he can reject them. He could just allow the Sheikh to expire. It would just kind of fizzle away. But in this case, again, for speed, I won't look at them, but he download them, review them, and then here he's happy with them. It's what we've agreed outside of Sheikh, so I'll approve the terms. And then, remember, we're still in the defendants builders zone. We've got to get to put our proposals in, and that represents our range of happy settlement, if you like. We're reminded that it's low to high because we're the defendant, and that it's including costs. So let's say the builder who thought it was who said originally, I won't give you more than 1,000. Let's say he recognises that the range is really from 1,000 via 1,900 to 2,200. So his walkaway point is a £2,200 settlement, and he'll submit those proposals. If they were kind of really out of whack with each other or in the wrong order, it wouldn't allow me to do it, but it asks me to check, and I confirm. And it says your proposal has been submitted, wait for the other one. So I'm going to log out as Bob again. I'm going to log back in as the house owner's representative. And I can see up here in my action required list, I've got build a claim, submit proposals. So I go in there, and as the claimant, obviously, my proposals go from high to low. So I'm hoping for a nearer 2,700, and my bottom one via 2,400 is 1,900. So that's my range, and I'll submit those proposals now, confirm that. Sheikh has a little think, and what it's doing is comparing the first pair of proposals that have been submitted. If they don't overlap, it moves to the second. If they don't, to the third. If they do overlap, it will find a settlement at the overlapping point. And in this case, there's a settlement there of £2,050. So Sheikh now emails all the parties with the details, the underlying terms, the details of this claim. And that is broadly it. So it's a simple, intuitive web application. It can be used at any point in a process, can be used more than once if necessary. And with something like 400,000 money and damages claims in a county court each quarter, it's obviously now is definitely the time to shake on it. I have to take any questions, but what I'd like to ask you is where this, and perhaps to pop in the chat, where you think this could make a difference. Who could it benefit? Where could it be used? What are the opportunities for partnering with organisations on this call? So interesting to hear from Amica, and I know there are others on the call that represent organisations where you're already providing ODR, but perhaps looking for a more linear negotiation approach. It'd be great to hear from you. And obviously from OPRC, whether there's scope for adopting it in the small claims process. Thanks, Emeline.
Thank you so much, Austin. That was a really brilliant presentation. And we do have about a minute before we go into AOB. So if anybody has any thoughts for Austin about those questions that he's posed to the group, do feel free to kind of pop in. You can raise your hand, or if you want to throw it in the chat. But I guess just off the bat, does anyone have any thoughts in relation to some of those questions that he's put to the group? See if I can see it now. Okay. Well, let's see. Austin, are you happy for me to, you've shared your email. Okay, brilliant. So in the last few minutes, if something does come up and you would like to flag with Austin, please do feel free to put it in the chat. Otherwise, I'm thinking, Austin, that if you're okay if people reach out to you, if they have a think about it, take it away and get back to you. So definitely do have a think about all of that, and feel free to reach out to Austin if anything comes up from that. And that reaches the end of our session. So very quickly, as part of our AOB, I'd just like to highlight that LawTech UK has an upcoming Access to Justice event. My colleague Jaira is going to post that link in the chat for anyone who's interested in attending, but it's going to be held on Wednesday, March 27th. And it seeks to explore innovative approaches and current challenges in ensuring equitable access to legal resources and services. My colleague Martha, who usually joins these calls, is going to be speaking at the event as well. So if anyone would like to chat with her beforehand about the content or suggest any topics or other speakers or anything like that, they can just get in touch with her directly or with myself, and I can put you in touch with her. Okay, well, that reaches the end of our session. I just want to say a huge thank you to all of our amazing contributors today. I feel like we had a really great discussion about dispute resolution and about next steps and where all of this is going to go. And I really appreciate you taking the time to share your learnings and your experiences with the rest of the community. And thanks to everyone as well who used the chat function. We're definitely going to include that in our follow-up. As always, I'll be sending out the meeting recording and the note in due course, hopefully sometime next week. In the meantime, if you have any questions or things that you'd like to flag, please do feel free to reach out to me directly. Our next meeting is going to be held on Thursday, June 6th at the same time from 10 to 11:30 a.m. And it's going to focus particularly around the issue of AI. So it should be a really interesting session. Again, this is currently a free session, so please do have a think about what you'd like to see, share, and discuss next. If there are any particular projects that you'd like insight on, or if there's an issue you'd like to explore, would be more than delighted to help curate a session around that. So as always, please do reach out to me. We're really keen to hear from you guys, and it's just fabulous that we're all able to get together for such a productive discussion. So I wish you all a really great rest of your week, and I hope to see you all at the next event. Thank you so much again. Have a good day.